Imagine being pulled over carrying a legal gun. You have a clean record and you do everything that's required under your state laws. But 5 minutes later, you find yourself standing there in handcuffs as a cop is not only digging through your trunk and searching, but tearing up the inside of your car. No drugs, no smell of marijuana, and no real legal cause. All you said was, "Officer, for safety's sake, I want you to know I'm carrying a legal firearm." Most gun owners have no idea that by saying or doing the wrong thing in this situation could lead to a full-blown search where cops can justify destroying your car. I'm Jeff Hampton, the People's Lawyer, and in this video we're going to walk through number 1, how courts really see stops, handcuffs, and car searches when you're armed. Number 2, when an officer can legally cuff you, quote, for safety, but still hasn't technically arrested you. And then number 3, how to make sure telling an officer, "I have a gun," doesn't automatically give the police the right to search your car. And wait around till the very end and I'll give you the exact sentence, the specific few words that you can use to not only stop cops from taking something like this too far, but to actually destroy their qualified immunity so that you can hold them accountable if they don't follow the law. Let's start with the true story of someone who went through exactly what I just described at the beginning of this video. Our driver starts off in Connecticut. He's in a neighborhood the cops described as a high crime area, which sounds scary on paper, but what you look, you'll find out all he's doing is driving down the road, following all of his state traffic laws, and he's merely carrying a firearm legally. But as the officers are following him, they claim they find some ticky-tack traffic issue, so they pull him over. And then as the officers walk up to the window and begin to question him about this traffic issue, all our driver does is look at the officer and let the officer know, "Officer, I'm carrying a firearm and I'm doing so legally." He then does what everybody else does in this situation. He hands over his driver's license. He even hands over his permit for him to be able to carry in the state of Connecticut. And the officer begins to see him as being very suspicious. But wait, no furtive movements, no nervous fidgeting around, no smell of weed, no smell of alcohol on his breath. He had done nothing wrong. But instead of treating this like a normal traffic stop, dealing with a driver who's exercising his Second Amendment rights to carry a firearm, the officer chooses to escalate the situation. He turns around and orders the driver out of the car, immediately places him in handcuffs, puts him in the back of his patrol cruiser where he sits for more than 30 minutes. And while the driver is stuck in the patrol car, the officer then proceeds to search number 1, the cabin of the car, number 2, the glove box, number 3, the center console, and number 4, even everything in the trunk. No warrant, no consent, no information this man has committed a crime whatsoever. The only thing he had was an actual legal gun owner telling an officer, "Officer, here's my permit, here's my license, and I want to be upfront with you right now, I'm carrying a firearm." In fact, essentially the officer begins to admit that the only reason he's digging into this man's car is because he was told he had a firearm, so now he's going to look for more stuff. And please understand, when cops decide they're going to search your car or your house, they don't just dig around and look a little bit and say, "Okay, we're done." They tear everything up. They'll rip the insides of your car out. They'll pull everything in the trunk out of the trunk. Many times they'll break items. They don't care. They're certainly not going to pay to repair it. They're tearing everything up that they can, and if they can do so, they'll do it under color of law. But that's the question here. This man had done nothing wrong. Now this is where it gets interesting, because the driver, he chooses to sue now, and the case goes all the way up to the Federal Court of Appeals. Now the judges have a very specific problem in front of them. They must answer the question, does the Fourth Amendment allow police to handcuff, detain, and search a vehicle solely because they know about a lawfully possessed gun when there are no other facts suggesting a crime? Now that's the court's question in this particular case. In fact, the name of that case is Sokana versus Andruski. It's a Second Court of Appeals case from 2024. But you might be saying, well, that's the decision that that particular court has to make. But I can tell you right now, if you're a legal gun owner, that's the question you must answer as well. Because when a cop pulls you over, is it worth really telling them you have a gun at all? Now, before the Second Court of Appeals lays out where our constitutional rights really kick in, they have to actually give us a crash course on those constitutional rights when it comes to the Fourth Amendment. Now, please understand, the Constitution doesn't say that cops can't perform any searches ever. Instead, what it says is that there must be no unreasonable searches and seizures performed by the police. So it makes sense here that cops can stop you, but only if they meet certain legal thresholds. For traffic stop situations, there's two legal thresholds we must understand. Number one, reasonable suspicion. Number two, probable cause. So let's break these down very simple. Number one, reasonable suspicion. If a police officer believes and has reasonable suspicion, articulable suspicion, that you are either number one, involved in some criminal activity, and you might be armed and dangerous, police officers can now perform what they call a Terry stop, which is a brief investigatory stop. During this investigatory stop, based on reasonable suspicions, cops can, number one, ask you questions. Now, it doesn't mean that you have to answer those questions, but they're allowed to ask them. Number two, they can keep you detained for a very short period of time. And number three, if they reasonably believe that you are dangerous, they can do a limited pat down of your outer clothing only for the limited purpose of checking for weapons. So yes, technically your gun here can matter when it comes to officer safety, but it cannot be the sole reason for why they decide they think you are suspicious, to think you are involved in a crime. There must be something separate from the actual legal possession of a firearm to rely upon by the police to get you out of that car and now believe and treat you like you're a criminal and claim they have reasonable suspicion of criminal activity. So here's the rule. Being armed where it's legal to be armed is never reasonable suspicion. Which then brings us to the second standard, probable cause. To go from temporary stop, just to see what's going on here, to effectively being under arrest raises the bar for what the cop must be able to prove. Now the officer needs probable cause, as it's known under the Constitution. And here the officer needs specific facts that make it more likely than not that number one, a crime has been committed, and number two, you are involved. Now you tell me, slapping handcuffs on a calm, compliant person, putting them in the back of a squad car and detaining them for more than 30 minutes, that starts to look a lot more, instead of a safety check, that's looking a lot more like an arrest. And if the cops are arresting him, it must be supported by probable cause. You say, wait a minute, Jeff, I've heard of this thing called an automobile exception to the warrant. Doesn't that allow cops to still be able to search your car without a warrant? Now, this is true. The automobile exception to the warrant requirement does allow a police officer to search someone's car, but they must still have probable cause that that car contains some type of evidence associated with the crime before they're able to use the automobile exception to search the vehicle. And here is where your gun, your legally carrying a weapon, comes in. A lawfully owned firearm is never considered contraband. Millions of people legally have them. And over the years in the past, courts have normally been very consistent with this principle. Police officers finding out that you have a legal gun does not by itself justify turning a minor traffic stop into an arrest or justify the destruction and ripping up of your vehicle during a search. So that's the legal framework, but here's what it means for you if you find yourself in a situation where the cops want to know if you're carrying a firearm. Number one, the officer can be cautious if they find out that you're armed. Number two, they are legally allowed to take limited steps to make sure no one gets hurt. But number three, they cannot take your legal possession of a firearm and magically transform it into an opportunity for them to search and turn it into a fishing expedition to tear up your car and try to find anything else they can that's illegal. Now, we'll see exactly how the court took this standard and applied it in our main case, and how you can use this script to stop cops from victimizing you in this situation. But first, we have to identify what can cops do and not do if you find yourself in the same situation. So let's say you've been speeding a little bit, and the officer pulls you over. He walks right up to your window and he says, "Any weapons in the car today?" Now, it's important to realize, depending upon the state that you're in, you might be required to disclose to that officer that you are carrying. In other states, you only have to answer the question if they ask it specifically if you're carrying. Either way, for this example, let's just assume for a moment that you do disclose, whether you have a duty or not. Let's assume you disclose to that officer you're carrying. You say, "Officer, before I reach for anything here," as your hands are up and you're not moving quickly and you're being very still, "before I reach for anything, I want you to know I am legally carrying a firearm today." You then do the smart thing and you keep your hands up and you say, "I'm going to keep my hands right here. How would you like me to proceed?" By saying this, the officer knows you're armed, you're honest, and you're not making any sudden moves. So what can they legally do with this information? The first thing they legally can do is order you to get out of the car. The Supreme Court has ruled in multiple cases that police officers can order a driver to get out of the car so they can be checked for officer safety reasons if it was a lawful traffic stop. Now you might be saying, Jeff, come on, I already know this is Pennsylvania versus Mims, and there has to be some evidence that I'm armed and dangerous, right? Otherwise, why get us out of the car? I want you to understand, for all intents and purposes, if an officer finds out that you have a weapon at all, they can almost use any excuse to force you to get out of the car. And if you don't get out of the car, they'll use it as an excuse to rough you up, charge you with resisting arrest, and things get much, much worse. But please don't misunderstand. Merely being asked to step out of the car may mean you're being detained, but you're by no means under arrest. Number two, they can then temporarily secure the weapon. Now, the Supreme Court has ruled that if an officer knows that you are armed, they are legally allowed to, number one, ask where the gun is. Number two, carefully disarm you. Number three, unload the firearm if appropriate. And number four, hold on to it until the stop is over. Is that annoying? Absolutely. Does it feel like you're being treated like the bad guy? Absolutely. But as long as it's tied to a lawful stop and they're not keeping the gun, then it's technically legal for the police to take these steps. Which brings me to number three. And by the way, this is a bit of a stretch here. If the officer believes you might be dangerous, they can then perform a limited pat down over your clothes to search for additional weapons. Now, this is not a full-blown search for drugs or documents or anything else that they find. They should only be feeling over the top of the clothes for anything that would immediately appear to be a weapon. And they're only allowed to do this type of search if they're able to or reasonably articulate that they believe you're actually dangerous. Why is this important? Because the spirit of this is it's supposed to be only a weapons-only check for safety for the officers. So yes, are they legally allowed to pull you out of the car? They are. Are they legally allowed to then secure your firearm? Absolutely. If they can articulate that they believe you're dangerous, which I don't think applied in this situation with our case that we're discussing here today, but they usually will articulate something in a police report where now they're going to use it as an excuse to try to pat you down and feel for anything at all that might be immediately apparent to be a weapon. But beyond what I just covered right now, that officers are allowed to do, this is where we draw a legal line in the sand and say anything beyond this now begins to become illegal. And this is very important because many people, including many police officers, believe that merely because you are armed gives them a full permission slip to now not only search you, your property, but tear apart your car and your trunk, all in the name that I'm afraid because he was armed. Which brings me now to exactly the things cops cannot do just because you are carrying. Number one, they can't turn every armed citizen into an automatic arrest. Which brings me back to our main case, Sokana versus Andruski, our second Court of Appeals case decided in 2024. Here the court, in their opinion, pointed to very specific facts that should be considered. Number one, that there was a calm, compliant driver. Number two, a valid permit, so this man legally could carry. Number three, he had disclosed that he had a handgun. And number four, there were no other suspicious facts. Which then led the court to hyperanalyze exactly the crazy actions the officer took. He, number one, pulled out the handcuffs. Number two, he locked the man in the cruiser. Number three, he kept him detained for over half an hour. And number four, he performed a full vehicle search, including the trunk, all in the name of because he just had a weapon. The second court came back and said, considering these facts, this is not a brief detention. This walks and talks like an arrest, and you've got to have probable cause in order to search and tear up a man's car. And when all you have is a valid firearm that you're in possession of, that's not enough. So remember, a cop discovering or being told that you're carrying a valid firearm, a legal firearm, never gives them an automatic permission slip to turn around and treat you like a common criminal or to tear your car apart all in the name of a search. Which easily leads me to point number two, which I already made, is that having a legal firearm never leads to probable cause for a search. And here's the crazy thing. This police officer who supposedly was trained, this is what he claimed. He said, quote, "Once I knew he had a gun, this gave me a reason to search for more contraband." That's what this police officer who supposedly was trained and went through the academy actually believed. The court rejected this reasoning by the police and said very clearly, a legal item by its definition cannot be contraband. And if it's not illegal, that can't be your reason to tear up someone's car in a search. So remember, if you have a legal gun, the cop can never use that under the Fourth Amendment as a basis to violate your Fourth Amendment rights to search your car. The cop, under the law, must have something else. What could something else be? Well, from previous Supreme Court cases, one example could be drugs in plain view. Another could be smell of something illegal in a state. And I say something illegal, I mean marijuana, in a state where marijuana is still illegal. Another court example is evidence that the gun itself is illegal and it's illegal to carry. And finally, another example, there's specific facts tying your vehicle to a particular criminal case or activity. Those type of additional facts could justify an officer escalating this to something more substantial like we found in our case in the Second Circuit. But without something else, there is no fishing expedition allowed under the law. Then, of course, this brings me to number 3. Cops cannot use you being in a high crime area plus having a gun as a magic formula to believe they can search you and believe you might be a criminal. Now, this one drives me crazy because cops love putting high crime area in their police report. Now, even though saying that someone is doing something in a high crime area sometimes gives cops justification to take certain actions, merely lawfully carrying a firearm and driving through a tough neighborhood doesn't automatically make you look suspicious. So what did we learn here? Being in the wrong zip code plus having a legal gun never equals automatic reasonable suspicion. And finally, I'm going to talk about some common bad advice and why it will hurt you. There are so many people that get themselves in trouble, not because of what the cops do, but because of what they say, the words that come out of their mouth. Here's some quick bad advice that I'm sure most of you have heard. Here's the first one. Quote, if you've got nothing to hide, just let the cops search. Or what about, if you're polite and cooperative, the cops won't push it. Or here's another one. If there's a gun in the car, cops are going to be able to search anyway. Now I get it. These might sometimes feel like good citizen moves. Maybe you feel like this is reasonable advice. But here's the problem. Number 1, nothing to hide, that's irrelevant. The Constitution doesn't say you only get constitutional rights if you're guilty. Oh, and what about if you'll just be polite and cooperate, the cops won't push it? Well, here's what most people don't think about. Cooperating very easily slides into the officer claiming you consented. And of course, the moment the cop can claim you consented, even impliedly, this now becomes a reasonable search in court. And if it was a reasonable search and you consented, now the cop can justifiably tear up all the inside of your car. I've always told this story about my 65 Mustang. I had a cop do this, pull out all the insides of my car, destroy the insides of my car, all because I consented when I was a teenager to allow him to search my vehicle. I learned that lesson the hard way and I'll never go that direction again. Remember, choosing to be polite and cooperate gives the officer a full license to destroy your vehicle because you consented. I bring this up because if you go into a traffic stop with bad advice in your head, you'll give up your rights as just part of small talk. So we now know what cops can and cannot do when they find out you may be legally carrying. We also covered the bad advice you should get out of your head before cops walk up to your window. But what are the things you can do right away, right now, before the cop even walks up to your window to protect yourself when things get a little tense? As soon as you see the lights, the red and blue lights behind you lighting you up, number 1, signal and pull over somewhere safe as well lit as you possibly can. Number 2, put the car in park. Number 3, roll down your window. Number 4, turn off your radio and make sure your interior lights are on. And number 5, put both hands on the steering wheel where they are obvious and never make any sudden moves. If you are carrying, never reach for your wallet or reach for your waistband or reach for the glove box as the officer's walking up. This is one of the most dangerous places because when I see this happen, cops tend to overreact and they'll assume you have a weapon that you're about to use. Now, if you're in a duty to disclose state, your state law will require you to inform that officer that you are currently carrying. If you choose to disclose to the cop you're carrying a gun, you better make sure you do it in a very non-threatening way. You can say something like this: Officer, before I reach for anything, I want you to know I am legally carrying a firearm. My hands are going to stay right here. How would you like for me to proceed? It's usually at this point, if you have a good cop, he's probably going to say, no problem at all, man. I'm sure you're carrying. Just wanted to check with you. If there's a traffic violation, he'll take care of it and let you go. If the officer starts to escalate things, now it's important to know how to respond if he tries to demand you get out of the car. Now remember, we've already covered. We know the law says the cop can force you out of the car, he can secure that firearm during the traffic stop, and if he believes you're dangerous, he can actually do a pat-down search on you. But here is where things get squirrely and cops love to set the trap. After they get you out of the car, they'll start to use phrases like this. You don't mind if I take a quick look in your car, right? Why don't you just pop the trunk real quick for me? Mind if I take a peek around? These are not safety commands. These are invitations for you to waive your Fourth Amendment rights. Now, most people overwhelmingly say yes because they're scared or they're polite or they don't really understand they're allowed to say no. But always remember, you always have the right to refuse consent to search no matter what a police officer says. Now, what if the officer keeps bearing down on you? What if the officer says, well, you have to understand, sir, because you have a firearm today, I have a right to search your car. Do you understand this? Now, I'm going to tell you, if it was me, I would be very tempted to say, actually, in the Second Circuit Court of Appeals, it says, but if I were to say that, or if you were to say that, how do you think that will go? All you're going to do is poke the bear and basically inflate the pride coming out here. The officer is now going to get upset. He's going to turn around and start arguing with you. And I guarantee you that officer is going to escalate the situation. So I generally remind people, it's not your job to win the legal fight on the side of the road. It's your job to, number one, clearly refuse consent to a search. Number two, politely ask the officer if you are free to go once the traffic stop is actually over. And then number three, shut up about anything else that could be twisted into probable cause that would prolong that traffic stop. Which brings me to my 4-step script you can use from start to finish to deal with a cop if he basically chooses to ignore the law, just like he did in the Second Circuit. If that cop chooses to ignore the law and tries to violate your constitutional rights, here's the exact wording you can use. Step number 1, if a cop walks up to your window and you're in a duty to disclose state and you feel like it's appropriate for you to tell the officer you're carrying a weapon, set the tone and you can say something like this. Officer, before I reach for anything, I want you to know I am legally carrying a firearm. My hands will stay right here. How would you like for me to proceed? And step number 2, if you disclose, good chance cop's getting you out of the car and now he's going to perform his safety checks. So if the officer demands you to get out of the car, remember, don't fight the issue. Say, yes, sir, step out of the car. If he then begins to claim that you're dangerous, if you argue about whether or not you're dangerous, now he's going to further provide support that you were dangerous. If instead you're polite and you're calm, which you're going to find out here in a minute in our Second Circuit case, that was key here in him being able to win under qualified immunity and destroy the qualified immunity of the cop. Now all of a sudden, you're making it clear the officer is being unreasonable. So even if the cop pats you down for weapons, detains you, holds your weapon, don't argue with the cop on the side of the road, and certainly don't pull away because you'll be given justification for the cop to claim you were being dangerous. Which brings us to step number 3. It's at this point the cop's likely going to say, hey, you don't mind if I search your car, do you? Hey, can you push the button to open your trunk? Or you mind if I look around here for a minute? Instead of hesitating or acting like you might be okay or looking over at your keys for the trunk button, immediately, without even thinking about it, stop and say, officer, I do not consent to any searches of my vehicle or my person, and I refuse to answer any further questions without my attorney present. That's all you have to say. Don't turn around and argue with the cop. Don't tell the cop he can't do it. Don't tell him he's violating your constitutional rights. Don't pick a fight with the officer on the side of the road because it will damage your claim for to bust that qualified immunity of the officer if he continues to violate your rights. And finally, step number 4, this is when the cop takes it too far. If he initially asks you and you refuse, and then he says, it's no longer a request, pop the trunk. If the cop chooses to completely ignore the law, just like it happened in our Second Circuit Court of Appeals case, now it's time not to fight him on the side of the road, not to get in a verbal argument with him about it. Instead, make it clear where you stand legally on the record. You can say, quote, officer, I want to be clear. I do not consent to any searches of my car or my person. If the conversation drags on after the ticket or the warning, it's important to add this to your line as well. You can say, quote, officer, am I free to go? Or am I still being detained? And then if the cop really takes it too far and does like he did to our poor guy in the story here in the Second Circuit Court of Appeals, and he forces you into the back of the car and he actually arrests you, now it's important to say, officer, exercise my right to remain silent. I will not answer any further questions. And now you're locking things down constitutionally and you're setting the record to show that the officer clearly violated your rights. So what happened to our driver back in Connecticut in our second Court of Appeals case in Sokana versus Andruski? Well, the appeals court reviewed all of the evidence and the facts, and they came to this ruling. Number one, a lawfully owned gun is never considered contraband. Number two, legally carrying a firearm can never be treated as suspicious just for following the rules. And number three, you cannot create a gun exception to the Fourth Amendment where armed citizens are being automatically detained and searched. Now, here's the best part. The court ruled that not only did they throw out the cop's justification, they also ruled that the police officer could be sued personally. They absolutely threw out the qualified immunity in this case and said that he was personally liable for his own actions. Now, this is a big deal because it's the legal system finally standing up and saying when a police officer chooses to ignore what the law says clearly under the Constitution and to just trample over someone's Fourth Amendment rights and detain them illegally, the courts have come back and said, nope, there's a price to be paid here, no more qualified immunity. Speaking of cops violating your rights during a traffic stop, what if a cop, instead of getting you out of the car and treating you like a criminal, all of a sudden, when he finds out you're carrying a legal firearm, decides he wants to run the serial number on your weapon during a traffic stop? Check out this next video where I'll break down how you can take certain actions to stop cops from running and checking your gun during a traffic stop. See you over there.